Great. Good morning, everyone, and welcome to Community Law Mediation Centre for Environmental Justice webinar series on the Irish Convention. Today is the third instalment in our series, and we're going to be looking today at access to justice. We're delighted to welcome you all here this morning, and we're especially excited to welcome our guest speakers, Gavin Elliott of Community Law Mediation and Ida Edling of the Aurora Swedish climate case. So Community Law Mediation set up the Centre for Environmental Justice in 2021 to work on bridging the gap between environmental and social justice issues. In other words, to bridge the gap between people and planet and protecting both. And today we're discussing the third pillar of the Irish Convention on access to justice. So when do environmental concerns become a matter of injustice, and who actually gets to go to court to protect their environmental rights? And this webinar could hardly be more timely. We're living through a Dáil-declared climate and biodiversity emergency, while inequality continues to rise in Ireland. But the potential financial risks of bringing environmental cases before the courts remains a live concern, alongside attempts to restrict access to justice for environmental NGOs. Strong environmental legislative and policy frameworks at the EU and national levels are really not providing the results that they should, because they're not being properly implemented. So access to justice is a really critical tool to reducing the gap between environmental laws and policies and their implementation. We will have time for a Q&A session at the end after our speakers have presented. So please do use the Q&A box at the bottom of your screen to ask any questions that you would like. And yeah, if you see a question that's similar to one that you would like to ask, please use the thumbs up function, so it makes it more likely that that question will be responded to. And as this is a short event, I'm not going to take any more time in the introduction. So I'm going to pass over to our first speaker, Gavin Elliott. Gavin is a practicing barrister with extensive experience in private practice, specialising in public interest, civil and regulatory law. Gavin is currently a lawyer with Community Law Mediation Centre for Environmental Justice and has previously served as legal officer with a housing charity. Gavin has been called to the Bar of Ireland and Northern Ireland. So Gavin, I'm going to pass over to you.
Thank you, Clodagh. Can everybody hear me? Okay, yeah, perfect. Welcome, everybody. This is our third and I think final webinar in the Irish Convention series. And as Clodagh said, we'll be talking about the third pillar of the convention, which relates to access to justice. If any of you were here at the previous sessions, we discussed the first pillar, access to environmental information, and the second pillar, the right to public participation in environmental decision-making processes. So I'm just going to give you a quick introduction, I suppose, to a couple of different concepts, why the access to justice environmental matters is so important, what the convention provides in relation to access to justice, and what some of the barriers and threats are to access to justice in environmental matters in Ireland, and particularly more recent legislative proposals which very much touch upon those issues of access to justice. Ida then will be discussing the Swedish climate case and the significance of this as a youth-led initiative, and why access to the courts is so essential in the fight for climate justice. So I think the two talks should hopefully complement each other very, very well. So why is access to justice in environmental matters so important? Access to justice is recognised as a right in international environmental law, Principle 10 of the Rio Declaration, as well as the Irish Convention itself, for central importance to access to justice in achieving the goal of environmental protection. This is generally, I suppose, being taken to mean less cost risk, although notably no legal aid, and more relaxed roles and standing, which we'll discuss in a little bit more detail in a moment. But beyond those things, I suppose there's also a moral principle at play. Climate change and environmental harms have a greater impact on marginalized communities. Destruction of the environment has reached such a level that the world of current and future generations is severely compromised. In the Centre for Environmental Justice, we provided legal assistance in relation to things like air quality concerns, damage due to flooding, toxic waste and pollution, environmental pollution and dumping, and negative environmental impacts of proposed developments. So we know that despite our laws, and many of them are good, the climate crisis and other environmental issues are not improving. Emissions are increasing rather than decreasing. According to the Environmental Protection Agency, only 20 rivers have pristine conditions compared to 500 in the 1980s, and air pollution contributes to approximately 1,300 premature deaths every year. We also know that important and protected ecosystems are being eroded and biodiversity loss is occurring on an unprecedented scale. We know that 71% of landfill sites and waste incinerators in the country are located in areas that are below the national average in terms of deprivation, which points to a particularly insidious issue when it comes to the effects of climate change and environmental degradation, insofar in that it very often hits the least able to, least resilient first. There's unequal access to green space, with more trees and more trees than residents, in Ballsbridge, and only 10 residents per tree in North Inner City in Dublin, which I suppose is a statistic that speaks for itself. But we know that having laws is not enough, and that we need to ensure that the law is enforced so that government, corporate bodies and others are held to account in relation to breaches of environmental and climate obligations. These include things like challenging developments through the planning system, because it's likely to generate significant emissions or adversely affect the environment through pollution or habitat destruction. Or it might include challenging climate policy in the courts for being vague and lacking in detail. And those are two of the areas in which the Centre for Environmental Justice has been active in the recent past. To ensure the law is enforced, we need to ensure that people and groups know that the law is there in the first place and how that it applies to their situation, and also that they know that they have access to courts, and imperfect as it is, that they have access to legal assistance if that's what they need. Judge Anthony Collins, who is a judge of the General Court of the European Union, called for improved access to the courts for activists due to the fact that Ireland has historically displayed, in his words, an astonishing reluctance to comply with EU environmental laws and only seem to pay attention when taken to court. I know from personal experience and from working in the area for some time that very often when we're talking about environmental protection in Ireland, we're talking about EU regulations and directives, and less often we're talking about homegrown initiatives. It won't be a surprise to anybody that the number of strategic climate litigation cases is dramatically on the rise, and we'll hear about one in a moment. But there was recently, Alex White, senior counsel, concluded that the majority of cases taken against governments in Europe have led to outcomes which result in greater climate regulation. So this area of climate litigation and strategic climate litigation is relatively new, and it's something that, as I suppose, is finding its feet a little bit in terms of holding governments to account. But I think, taken as a whole, while there's successes and failures in the round, the climate litigation, as it's developed over the last maybe 5 or 10 years, does lead to more positive outcomes and greater regulation. Importance to access to justice in environmental matters has been somewhat recognised on an institutional level. In the last decade or so, Ireland's made significant changes to its standing and cost rules as a result of its adoption of the Irish Convention. Further, the judgments of the Court of Justice of the European Union and communications from the European Commission have consistently made a link between access to justice in environmental matters and environmental protection itself. As I said, it should be noted that the environmental law has traditionally been reliant on the European Commission for enforcement, but the Commission, perhaps to some extent, has started to withdraw from enforcement and is now outsourcing enforcement to environmental NGOs, arguably by systematically promoting access to justice for such groups to the national courts. So what does the Irish Convention then provide in relation to access to justice? Ireland ratified the Convention in June 2012. Article 1 of the Convention provides that each party must guarantee the rights of access to justice in environmental matters, for example, through judicial review or other claims. Article 3 provides that each party shall take the necessary legislative measures to achieve compatibility with access to justice provisions. And Article 9 specifically deals with the third pillar, access to justice. The key cornerstone of this provision is to ensure that the first two pillars are upheld. Article 9 then, as I said, relates to Article 9 relates to access to information, ensures that any person who believes that their request for information has been wrongly refused or inadequately answered should have access to a court, tribunal, or other similar independent body established by law to review the procedure. Article 9.2 talks about public participation, and it's designed to ensure that any affected members of the public should be able to review the substantive and procedural legality of any decisions within the scope of Article 6, which itself relates to public participation and decisions on specific activities. This right is granted to members of the public concerned who have this is quote, sufficient interest and impairment of right. The details of what constitutes sufficient interest and an impairment of right is a matter for national law and is usually assessed when an application for judicial review is made. However, it is important that in that sort of margin of appreciation that national governments are given, that they apply that with the objective of the Irish Convention, which is that the public concern should have wide access to justice, and that phrase "wide access to justice" is obviously quite important when it comes to determining what national governments can do or can't do in terms of their own national rules. So under the Convention, NGOs who are active in environmental protection are recognised by the Convention as having sufficient interest. In Ireland, the law changed under the Environment Miscellaneous Provisions Act 2011. It had been the case up until then that an applicant had to show substantial interest, but in foot of this piece of legislation, and because of the public participation requirements of the Irish Convention, it was changed to sufficient interest. So changed from substantial to sufficient interest. Article 9.3 of the Convention relates to breaches of environmental law. This item ensures that members of the public have access to administrative or judicial procedures to challenge acts or omissions by individuals and authorities who breach national environmental law. And finally, Article 9.4 talks about the procedures mentioned above, and that they should be fair, equitable, timely, and not prohibitively expensive. What's timely, I suppose, depends on the complexity of the matter and varies. And in relation to what is prohibitively expensive, it's not really defined in the Convention. But the implication is that there should be, national government should ensure that an applicant is not put off seeking remedy by virtue of the costs involved. As we'll see in a moment, while costs are still an issue in Ireland, and that does provide a threat to and a barrier to access to justice, the situation is eased a little bit by virtue of some provisions under Irish law, such as Section 50B of the Planning and Development Act 2000, and Part 2 of the Environmental Miscellaneous Provisions Act 2011 relate to breaches of planning conditions. And those sections in Irish law, I suppose, are a response to the not prohibitively expensive rule in the Irish Convention. Normal rule in courts in Ireland is sometimes summed up as costs follow the event, which means that the losing party in a case pays the cost of both sides. So if it was a personal injuries case and you take the case and you win, generally your costs of your lawyers and the costs of the other side's lawyers will both be paid by the losing party. However, it's a well-known feature of Irish courts that it can be a very expensive process. Costs can be significant, and could be particularly significant, obviously, if you're challenging in complex matters, and environmental litigation is often complex. So the rule that costs follow the event can act as a significant deterrent in every aspect of law, but particularly in environmental law. Section 50B of the Planning and Development Act changes that general rule somewhat So the special rules apply in cases involving the Environmental Impact Assessment Directive, the Strategic Environmental Assessment Directive, on the assessment of the effects of certain plans and programs on the environment, the Industrial Emissions Directive, and the Habitats Directive. Under these rules, a member of the public, if they lose their legal challenge, will generally only be fixed with their own costs and not the cost of the winning party. Whereas a member of the public wins a legal challenge, they may be entitled to their costs from the losing party or part of their costs, depending on the case. It's possible to apply to the court before or during proceedings for determination that cost protection applies, which gives a little bit of comfort as well to an applicant. So that's a very important aspect of the regime where at an early date in the proceedings, an applicant can get an indication from the court whether or not they are likely to be subject to potentially a huge cost order if the matter goes on. These special rules were to give effect to the obligations of the state to rectify its failure to properly transpose the public participation directives following a decision in Commission v Ireland. In that case, the CJU found that the pre-existing regime in which the High Court had discretion regarding costs did not comply with the directive because it lacked certainty. Final thing to bear in mind in relation to Article 9 is subsection 5, which provides that appropriate assistance mechanisms must be considered to remove or reduce financial barriers to justice. However, this has been held as not having an impact on legal aid. As may have been discussed during previous sessions, it's also worth bearing in mind the Irish Convention Compliance Committee. This committee ensures compliance by the parties to the convention and allows members of the public to communicate concerns directly to the committee. The committee can't make binding decisions, but it makes recommendations which are usually followed. There have been about 9 or 10 complaints against Ireland since 2013, and some of those have been deemed admissible. I suppose the utility of the compliance committee has been questioned by some, and there's certainly it's certainly a frustrating process, I think, to making a complaint to the compliance committee, but still it's probably useful that it is done so that it gives an idea of what the interpretation of the committee is in terms of the convention itself. So to move away a little bit then from the convention itself and focus a little bit more on Ireland. We've already mentioned the cost rules for certain cases and Section 50B and various other pieces of legislation, and the cost barriers themselves. So where these amended rules apply, the result is a much improved access to justice. Thing to bear in mind is that lawyers will often take cases on a no win, no fee basis, or no fee basis, which means that lawyers will agree that if you lose your case, they won't pursue you for costs. Now the other side may still pursue you for costs, but they agree that they won't. However, if they win, they will seek their costs from the other side. But still, applicants can take cases knowing that their financial exposure is, if unsuccessful, is limited to court fees and outright costs only, if it's taken on that no fee basis. It's not always possible to find a lawyer who's willing to do that, and there's not always been certainty in terms of the new cost rules and whether they apply to the entirety of a case or not, and that can be sometimes a little bit difficult to determine. Some aspects of a case may fall under the cost rules and some may not. Ireland has been criticised in many places, not least by the Commission itself, as being a member state in which access to justice is extremely expensive. Our current legal aid scheme, which is under review at the moment, does not provide legal aid for companies, so therefore not for NGOs. And while individuals aren't specifically excluded from legal aid in environmental matters, there seems to be a reluctance on the part of the legal aid board to entertain those types of cases, and certain exclusions may be what are being used by the legal aid board to not entertain those types of cases. These include things like exclusions related to interests over land, actions representing a group, or actions looking to establish precedents or a particular point of law. So those are things that are excluded from the remit of the legal aid board, and as such, while there's no explicit exclusion of environmental matters, in practice there can be. The law is particularly inaccessible for vulnerable or marginalized groups, people who are disproportionately impacted by environmental problems, and these groups can feel largely excluded from environmental and planning making decisions. Members of the public who have a sufficient interest or impairment of rights may not know their rights under the convention, or that they can go to court in relation to the acts or omissions when there's a breach of environmental law. So there's a huge gap, I think, in public knowledge of the convention and public knowledge of environmental rights in general, I think. Irish policy is traditionally pulled towards making it a little bit more difficult to challenge environmental decisions in court. And international and EU law have tried to make it a little bit easier. So there is that tension, I think, as well, if we looked at it in the round. One other thing I think to consider in terms of barriers to justice is how some issues are presented, particularly presented in the media and by politicians. So we have stories quite often about I suppose, a growing industry of legal challenges which are holding up much needed house building. NIMBYism, stories about how easy it is to take judicial reviews and how apparently they're taken at the drop of a hat by every residents group in the country. Those stories are not true. They misrepresent the statistics behind the numbers of judicial reviews that are being taken. But I think stories like that do represent a barrier to justice as well, because that narrative, I think, makes people less willing to exercise their rights to a proper legal remedy. However, one of the things that I think has resulted from these stories and from this narrative is that there's an urgent need for reform of the planning system. And in fact, I think that's probably a correct conclusion, perhaps drawn from the wrong data, but a correct conclusion nonetheless, that there is a need to reform the planning system. And this has led to the publication recently of a draft planning and development bill, which was published earlier this year and which was approved by Cabinet in the last number of weeks. This bill hasn't been published yet, so what we have is a draft bill which underwent pre-legislative scrutiny and a decision from the Cabinet, but we haven't really seen the final text that the government intends to introduce into the Oireachtas. And there is some indication, although it's very difficult to tell, but some indication that the final piece of legislation that the government intends to introduce may be a little bit different from the draft bill. So what I'm going to talk about now is some of the provisions in that, but just to say it's very much based on the draft, and we're not even entirely sure that the draft represents something close to the final text, which is likely to be introduced in the next couple of weeks, or likely to be published in the next couple of weeks, introduced. I think the idea was to have it passed before Christmas, but that seems very less and less likely with every passing week. So this particular piece of legislation is very much framed as a response to the housing crisis, to increase house building, and as a complete overhaul of the planning system and related court processes. It went to, as I said, the Joint Committee on Housing and Local Government and Heritage, who published their report on it in April. And that report was very detailed and made an awful lot of recommendations. A lot of the recommendations that it made were recommendations that were made by legal professionals, NGOs, and others who had concerns about these particular provisions. The stated aim of the bill is to increase efficiency and speed of the planning process in order to remove perceived impediments. Obviously, while housing is urgently needed to address the social catastrophe brought about by the housing crisis, the bill is very unfortunately unlikely to achieve its aims and is much more likely to backfire and lead to years and potentially decades of satellite litigation around its provisions. Firstly, I think because it's based on a flawed premise, that there's some sort of tsunami of judicial reviews holding up the projects. As I said, only 1% of the circa 30,000 planning decisions made annually are ever judicially reviewed, and around 3.5% of on-board planola decisions. And I think also we need to look at the amount of those judicial reviews that are actually successful, and therefore judicial reviews which should have been brought. Secondly, because the bill conflicts with international and EU legal principles and obligations surrounding access to justice, as we've seen, specifically through restricting access to public participation and access to review and planning, and thereby reducing accountability, and through centralizing powers in the planning system in undemocratic ways. It's worth noting that judicial review of planning decisions is already subject to a more restrictive regime than other administrative decisions, which was introduced in the Planning Development Act 2000, and this bill proposes to restrict access to justice even further. So, for example, if you were to judicially review the decision of Minister for Finance to make certain provisions, you might have 3 months to do that, whereas if you're reviewing a planning decision, you have 8 weeks or whatever to lodge the judicial review. And there's many other aspects of that, but essentially judicial review of planning decisions is already much more restrictive than other judicial review regimes. The bill has emerged from a relatively opaque 15-month review process conducted by the AG's office and the Department of Housing. There's really been very little in the way of public consultation on the bill. A closed invitation-only consultation with stakeholder group. The stakeholder group was established, and there was a specifically created planning advisory forum, a body which, according to public documents, is composed almost entirely of industry and government representatives, with only 4 civil society representatives out of 39 members. This lack of public consultation conflicts with the requirements of the Convention, Article 8 specifically, which deals with legislation and how it should be passed. And that article is clear in the manner in which legislative proposals should be put out to consultation. The ARIS Implementation Guide, which is considered an authoritative source, stipulates that legislative proposals on development must be subject to public participation through the publication of draft legislation, provision of sufficient time and response. The lack of public consultation in this instance is striking for what amounts to a massively historic and significant reform of land laws in Ireland. One of the striking aspects of this particular process was the pre-legislative scrutiny undertaken by the Oireachtas Committee, and how much more how they engaged in a much wider exercise in public participation in gathering evidence than the government did itself in preparing the bill. A major departure for the bill is the restriction of NGO standing. Currently, any environmental organisation pursuing environmental objectives for the past 12 months can avail of the provisions granting automatic standing. The current rules derive from Article 2 of the Convention, and currently Irish law appears to allow for unincorporated associations to meet that criteria. That is subject to a reference to the European Court of Justice. But anyway, so under the proposed changes, unincorporated associations would no longer have standing. The draft bill only accords automatic standing to NGOs, which are 10-member companies that have environmental objectives, registered in existence as a company for at least 1 year prior, pursued the environmental objectives 1 year prior, and have passed a resolution to take judicial review proceedings. One of the most frustrating parts of this legislative process has been that we're operating to some extent off press releases. So while the provisions around unincorporated associations were in the draft bill and were discussed at the Oireachtas committee, when the proposals went to cabinet in the last couple of weeks, there seemed to be a suggestion that the rules in the draft bill around unincorporated associations would be removed when finally a bill was sent to the Oireachtas. So that's very unclear at the moment. And the fact that it's unclear, I think, is telling. The intention would seem behind those changes are the elimination of challenges by residents groups, and a contention that's sort of supported by the outline of bill published in 2020, which stated that members of such groups could take challenges in their own name. It would also eliminate long-standing environmental organisations who are incorporated but do not meet the 10-member rule. Proposed changes represent a substantial narrowing of the number of organisations that are eligible to avail of automatic standing provisions, and there are likely to be a breach of the obligation to ensure criterion-based restrictions on NGOs are subject to ensuring the, talked about earlier, that wide access to justice principle. And the findings of the Irish Convention Committee as well would seem to suggest that there are problems with the narrowing of NGOs to such an extent. The bill also contains significant amendment to the cost regimes, as we talked about, each party bearing their own costs, and that this regime is far from perfect. But there is a vague provision in section 250, and just to say that this piece of legislation is more than 700 pages long, but section 250 of the draft bill asserts that there will be a scheme to deal with costs. Gives very little information about that, other than it'll be introduced by the Minister for the Environment, Climate and Communications, or a body authorised to do so on his behalf. So it's really impossible to tell what this provision is, given the lack of detail, or determine how it would work, and whether or not it would be compatible with the provisions of the Irish Convention.
Gavin, sorry
Yeah.
to interrupt you here. Sorry, if you could maybe wrap
Sorry.
your presentation in the next couple of minutes, and then we'll hand over to Ida, just so that we have time for questions at the end, because we've had a couple of interesting ones come into the chat box. So sorry.
Apologies, I'm running way over time. Sorry
No,
about that.
no.
So yeah, I'll just skip to the end. So to conclude, so access to justice is essential in the implementation of the Irish Convention. It's an important tool in holding government and other bodies accountable, and holding them to their legal obligations, and ensuring that the all declared climate and biodiversity emergencies treated with the urgency it requires. The legislation that is being introduced in the new planning bill is not consistent with that, and as I said before, will lead to challenges to it, constitutional challenges and challenges to European courts. Thank you, and apologies for overrunning. Sorry about that.
Not at all, Gavin. Thank you so much. I'm so sorry to cut you short. Only for the reason that we do have some interesting questions coming in, and I think it'd be great to have a discussion with the audience at the end. So Ida, I'm going to pass over to you now. So Ida Edling is a lawyer and environmental activist. She's spokesperson and legal and scientific coordinator at Aurora, which is a youth-led association who are suing the Swedish state for insufficient climate action. Ida is also coordinator of advocacy, funding and counselling at Sweden's Environmental Association Law. So we are so lucky to have you here today, Ida, and thanks so much for joining us.
Thank you so much for inviting me. I'm just gonna make sure everything technical is working. Can you see my screen?
Yeah, we can.
Brilliant. Let me just start the slideshow. Okay, now all set, right?
That's perfect. Yes. thank you.
Okay, brilliant. So thank you again for inviting me to this very important webinar series. I'm going to talk today about suing the state for insufficient climate measures and how this is entirely impossible without access to justice. And so I am from the youth-led association Aurora, as Clodagh already said, and we are youth-led, meaning that our board consists entirely of people under the age of 35, now actually under the age of 27 too. And the idea to sue the Swedish state for insufficient climate action was born in 2020 and was born from the deep-seated desperation that many young people, even in privileged Sweden, feel about the urgent planetary crises that are affecting this globe. And so we found we have to do something. We have to take our responsibility, even though our leaders, our politicians, our economic people in power do not take theirs. So we filed a lawsuit against the Swedish state in 2022, and we did this in the form of a class action lawsuit, which means a whole group of people were signing, and in our case, it was 300 youth under the age of 26. And where we are at now in the proceedings is that the district court, the first instance court, issued the lawsuit in this spring, and we are currently still on the issue of standing, and we are now at the level of district court, but may be elevated to the Supreme Court in a special Swedish procedure. And the first question that I have to answer is, why are we bringing a climate case? And as I already was talking about a little bit, we are in an incredibly urgent climate emergency, and urgent action is needed. And I've chosen this quote from the IPCC, the UN climate panel, saying that any further delay in concerted anticipatory global action on adaptation and mitigation will miss a brief and rapidly closing window of opportunity to secure a livable and sustainable future for all. And I think this quote is good because it highlights that unless we do something in this decade, in these years, unless we transform our entire economic system and change our societies and economies at unprecedented scales and speeds, then we will have violations of our human rights. We will have significant risks and harms to people and ecosystems and plants and animals. And these harms are already occurring, but in the most affected areas of the planet. And as Gavin already talked about, these the people and ecosystems affected are often those least responsible for causing this crisis. And we're saying in our case that even though we live in Sweden, who's very responsible, has emitted a lot, and who is also very protected from climate harms, even though we live in such a privileged country, our human rights will be affected in the future. That's how serious this crisis is. And so in this very urgent crisis, we figured that we need to use all legitimate tools available to us in order to make change happen, transformation happen. And we chose law because we saw law as an unignorable tool. And by this, we mean that everyone needs to have some sort of relationship to the law. It's very possible to break the law, but if you break the law, that has consequences. And our idea is that with this case, we are bringing those consequences and holding the Swedish state to account for their failure to do enough in the climate crisis. And the second question that we often get, particularly in international settings, is why are we suing Sweden? Because Sweden is pretty good at greenwashing their climate policy and often seen as a climate leader. And so I just want to quickly run through the reasons or the limitations and the flaws of Swedish climate policy. And when we identify these flaws, we're always starting from the perspective of science, looking at what global and local climate science says is necessary to mitigate the climate emergency in a sufficient manner. And so the first message from science is that if you want to reduce your climate impact sufficiently, then you need to reduce emissions from all sources and not do, like Sweden, just reduce emissions in one category in exchange for increasing emissions in another category. And Sweden does this through exchanging the burning of fossil fuels for the burning of biofuels, causing equally large or larger emissions in the near term. And like I already said, the near term is what is relevant and important in the climate emergency. The second part of, or the second scientific message that we base our claims on is that if you want to reduce your climate impact, you need to support uptake of greenhouse gases from the atmosphere. And the only safe and doable method of doing that today is through conservation and restoration of ecosystems like forests, wetlands, and oceans. The Swedish climate policy, however, includes no targets on how much, how many, or how large such ecosystems should be protected. So that's another major flaw. The third scientific message that we base our claims on is that if we want to reduce climate impact in a sufficient manner, every country needs to do their fair share of the global climate measures necessary to limit global warming to 1.5 degrees. And this fair share is calculated based on many factors, but two of them are responsibility and capability. And I've already talked a bit about this, but responsibility refers to how much you have emitted historically and now, and capability refers to your resources and being able to take sufficient climate action. And so if you're a rich country like Sweden with high emissions historically and now, like Sweden and Ireland, maybe, I'm not sure, then you have a large fair share and a large responsibility to do a lot and take drastic climate measures. Sweden's current climate policy, however, includes no calculation of their fair share, but their ambition is not in line with scientific and legal calculations of fair share. Finally, or I just want to add that, and this has a very important climate justice aspect, because Sweden is a country that holds a large responsibility, but is not using their capability. And so it's important to sue these states because they have a large responsibility and they can also do something. So from a anti-colonial and climate justice perspective, it's important to sue states like Sweden. Finally, even though the climate emissions or Swedish emissions reductions targets are so insufficient in many ways, they are not even expected to be met. And so we find this unacceptable, which is why we're suing them. And I just want to go back to why climate litigation is such an important tool for climate justice, because there are many tools for climate justice and many of us are using many of them. But the importance of using law and the importance of having access to courts where you can use this tool is, first of all, that it's an opportunity to hold failure to account, because our future and the lives of people and ecosystems today are not merely up to the whims of politicians. There are legal frames for what they are free to do. And I think that the United Nations Environment Programme puts this in a good way with this quote. Another point of using climate litigation as a tool is that there's a potential for actual policy change. If you are victorious in court, you can get a court to define an obligation for a power holding entity like a state or a government. And this type of hard tool is something that we don't have many of them in the climate justice struggle. Finally, an important point of climate litigation is that it presents a powerful platform for climate justice advocacy, because the story of bringing a legal action, the story of a David and Goliath case where, for example, 300 young people are taking on the state, that's an attractive narrative for media to tell. So we have found that it has given us an important platform to advocate for climate justice and perhaps let voices that are not as often heard be heard. Of course, there are limitations to this methods. The strategic litigation method, for example, we are arguing based on frameworks that perhaps hold limitations in themselves, and perhaps there's a need for a larger transformation of these legal frameworks than what strategic litigation can bring about. Finally, I want to say something about how access to justice has been very important in the Aurora case specifically. First of all, I want to say that there is no specific climate remedy in Sweden, so there's no given path to take if you want to challenge, for example, a climate plan. There are no ways to appeal climate plans in Sweden. And we are also, this is also part of the reason why we are not directly reliant on the national implementation of the Aarhus Convention Article 9 that we heard about. But we are instead using the Swedish procedural law on civil procedure and bringing a human rights-based case with fiscal persons as the plaintiffs. And using the civil procedure rules means, like Gavin also talked about, means high economic risk, because the main rule in Sweden is also that if you lose, you have to pay your opponent's legal costs. And for us, this means risks of up to 1 million euros, sort of, which is of course a barrier for a youth-led organization to bring a case like this. Some conclusions, I'll just go through them quickly because I know the time. I just want to say that access to justice is what has let us bring this case and potentially cause policy change, and already use this platform to advocate for climate justice. And the urgency of the climate crisis, it calls for hard tools, and there is no tool for climate justice that is enough in itself, since we need to transform our societies in ways that are unprecedented. But climate litigation is potentially a powerful tool, and one of the powerful tools, and this is entirely impossible to use without access to justice. Thank you.
Thank you so much, Ida. That was absolutely fantastic and so inspiring to hear about the legal action that you're taking against Sweden. And I think you're right that many of us would, in Ireland, look to Sweden as an example of a state that's maybe doing better than we are. So it's interesting to see how that's actually not necessarily the case, and how Sweden also needs to be held to account. I just want to say thanks to the audience for these fantastic questions. We're going to start on them now, but please do feel free to keep them coming. We have about 10 minutes left. So Gavin, I'm going to come to you first. There's a question here. Why do you think efforts are being made to restrict access to justice on environmental issues? You're just on mute there.
I think there's a couple of things, like as I said before, I think there's the narrative around judicial reviews being taken, and how that relates to the housing crisis, for example, in terms of house building and development. I also think that historically, bodies like Bord Planola haven't been particularly good at making decisions that are legally sound, which has led to a lot of challenges. And I think those challenges are probably something that if you were the government, you would look at as something that was maybe an unwelcome feature of the system. So I think that it is probably or the government would probably view it as being in their best interests to reduce the number of challenges that are being taken, because every challenge that's taken, if it's successful, then imposes an obligation on the government. So I think it is probably as simple as that, people challenging the state on environmental grounds are just seen as, annoying and holding things up. Thanks,
Gavin. Yeah. Ida, there's a question here for you. Do you see restrictions to, well, it says public participation, maybe public participation or access to justice in Sweden, as is the case in Ireland? Do you have thoughts on that?
Yes, absolutely. Public participation, I want to say, is not my area of expertise, but I can just say what I thought of just off the top of my head. We have a pretty strong tradition of public participation in Sweden, but there have been examples of cases where that has been lacking in environmental matters. For example, there was an establishment or a continued permit for a limestone quarry at a Swedish island, and the government decided to, in order for this permit to be able to be continued, they decided to adopt a law just based on this particular case, which is in clear conflict with many important legal and constitutional principles. But in this process, there was also way too limited time for public consultation. So there are such examples, but perhaps not as systemic issues as in Ireland. Just off the top of my head. And to access to justice, yes, there are definitely barriers. One of them is cost, like we both mentioned, and another is that its national implementation of the Aarhus Convention only holds possibility for, or it's allowed according to the Aarhus Convention to restrict which environmental NGOs can have standing, and so in Sweden those restrictions have been criticized for being too restrictive. And strategic litigation is not very commonly used in Sweden, but it is increasing because of influence from European legal systems, for example.
Yeah, which is really great to see. Gavin, there are two kind of related questions here for you. The first is, how can citizens ensure that access to justice is protected? And the second is, how can we raise awareness to residents groups and NGOs of the changes being made under the Planning and Development Bill?
Well, in terms of the first one, I think unfortunately, if the bill passes in its current form, or what we think is likely to be its form, then protecting access to justice is a large part of that, is going to be NGOs and individuals bringing cases to court and potentially bring them to European courts to have the particular provisions of the Act kind of challenged in that way. However, I think as well, the second question is kind of related to that, which is that it isn't law yet. So there's still that opportunity to lobby politicians, to contact politicians and to make their views known. I think that residents groups in particular are probably one of the groups that are going to lose out, because the new standing rules in whatever form, whether unincorporated associations are allowed or not, are going to be hugely disadvantaged from the position that they're in now in terms of bringing any sorts of challenges under the planning regime.
Brilliant. Thanks for that, Gavin. And Ida, I'm going to give the last question to yourself, which is, how can young people become more aware and more engaged with climate justice?
I actually heard a leading Swedish climate journalist say the other day that the two main reasons for increased climate reporting in Sweden recently has been, first, that climate change is more and more evident, and second, climate activism. It's climate activists advocating and being heard. And so I think that in order to raise awareness of both the urgency of the climate crisis and what we can actually do to mitigate that crisisness, I think that advocacy and activism and making our voices heard is crucial. And we're often talking about the democratic rights that we have been granted in Sweden. We are free to protest and to make our voices heard. And so we also have a responsibility to use those rights and to highlight that this emergency is caused by ourselves and affects other people most grievously, and other ecosystems and plants and animals as well. So I think that young people can become more aware if we all start utilizing our democratic rights and take our responsibility to advocate for action in the climate emergency. And this includes advocating about climate rights and using those climate rights, because if we use them, then other people can take inspiration from that and can know that it's possible. So I think that if you manage to use your climate rights and manage to get attention to that, I think that that is engaging.
Thank you so much. What an excellent response. Thank you so much to both Ida and Gavin for your amazing contributions this morning. Ida, if people want to know more about your climate case, where can they get more information?
I can send the website in the chat, or I can send it to you.
Yeah, that'd be fantastic. Thank you so much. On the subject of climate litigation, some of you may know that Community Law Mediation have launched a legal challenge on behalf of Friends of the Irish Environment. We are seeking to challenge the government's Climate Action Plan 2023 because it doesn't detail how Ireland's emissions will be reduced or if they will be reduced in line with Ireland's legally binding carbon budget. That's also a live challenge that is one to watch, and we'll keep our website and social media channels updated on that. So please do keep an eye out for that. If you missed earlier webinars in this series, they are recorded and uploaded to our YouTube. And just want to say thank you to everyone for tuning in today. Thank you again to Ida and Gavin for your fantastic contributions. And thanks to the audience for just such brilliant questions and for engaging with us on this really important topic. So thank you so much, everyone.
Thank you to the organizers.
Thank you. Thank you.